5 seconds to go. Start. The appellant in this appeal was convicted for an offence punishable under sections 279 and 304A of the Indian Penal Code for causing the death of a 7-year-old girl on account of his rash and negligent driving of his tractor. The appeal from the said order and conviction and sentence having been dismissed by the learned sessions judge, the appellant moved in revision before the High Court. In revision, the Karnataka High Court, while confirming the conviction, set aside the sentence in respect of the offence punishable under section 279 of the Indian Penal Code, but maintained the conviction and sentence in respect of the offence under section 304A of the Indian Penal Code, whereby the appellant was sentenced to undergo simple imprisonment for 6 months and to pay a fine of rupees 2000, and in default of such payment to undergo further simple imprisonment for 3 months and also to pay a fine of rupees 600 for the offence punishable under section 279 IPC, and in default of such payment to undergo simple imprisonment for a month. In this appeal, the appellant has challenged the order of conviction and sentence passed by the Additional Civil Judge, Junior Division and Judicial Magistrate, and the subsequent orders passed by the Sessions Court and the High Court, maintaining the conviction under sections 279 and 304A and the sentence in respect of the conviction under section 304A IPC. During the hearing of this appeal at the admission stage, learned counsel for the appellant informed the court that the matter had been settled between the parties and a compromise petition had been executed between the appellant and the complainant. On such submission, the complainant was impleaded as a party to the present proceedings, and the short point which ultimately arose during the hearing is whether the offence under section 304A could at all be compounded, since the same is not covered by the provisions of section 320 IPC. The aforesaid question has troubled this court on different occasions, not only in connection with compounding of offences punishable under the criminal justice system, but also in respect of civil matters and in respect of matrimonial matters in particular, where the court had to strike a balance between the rigidity of the law and doing substantial justice to the parties. In order to meet certain unusual situations, this court has from time to time taken recourse to innovations and the powers vested in it under Article 142 of the Constitution in order to give a quietus to a litigation demanding a pragmatic solution. It has also been consistently held by this court that when an offence did not come within the ambit of section 320 of Criminal Procedure Code, but the proceedings taken on the basis thereof deserved to be terminated, a sentence could always be reduced while maintaining the conviction, and in most cases the sentence was reduced to the period of the sentence already undergone. In other cases, where circumstances so warranted, even the sentence was altered, which at times brought the proceedings within the scope of Section 320 of Criminal Procedure Code, and the offence was allowed to be compounded. Such being the position, and in the absence of any allegation of the misrepresentation or fraud made by the appellant cannot be permitted to raise the allegation of misrepresentation or fraud for the first time in this court. Moreover, for the sake of argument, if we consider that the respondent had fraudulently entered another date of birth in his service book, as had been alleged, it should have come to the notice of the authorities during his course of service, and not after he had attained the age of superannuation after the expiry of the date mentioned in the service book, which was based on the affidavit of the respondent. To the contrary, none of the officials responsible had noticed this during his service period, even during his time of promotions, when the service book was required to be inspected by the officials. Therefore, it clearly points out to the gross negligence and lapses on the part of the authorities concerned, and in our view, the respondent cannot be held responsible to work beyond his date of birth as mentioned in the matriculation certificate, when admittedly in the service book after affidavit some other date of birth was also evident. In view of the aforesaid circumstances, the appellant ought to have deleted the date of birth entered in the service book of the respondent on the basis of his affidavit, as the appellant had already accepted the date of birth of the respondent on the basis of his matriculation certificate, which was also produced by the respondent. The appellant alleged that the respondent had entered a second date of birth in his service book at a later period of time. The respondent vehemently negated this contention, stating that two dates of birth were entered simultaneously in his service book by the department officials. It is not needed for this court to verify the veracity of the statements made by the parties. If at all the respondent entered the second date of birth at a subsequent period of time, the authorities concerned should have detected it, and there should have been a detailed inquiry to determine whether the respondent was responsible for the same. It has been held in a catena of judicial pronouncements that even if by mistake higher pay scale was given to the employee without there being misrepresentation or fraud, no recovery can be effected from the retiral dues in the monetary benefit available to the employee. This court, in the case of Kailash Singh versus the state of Bihar and others, held that recovery sought to be made from the salary of the employees on the ground of alleged overstay in service on the basis of age assessed or considered, despite the fact that the employee has worked during the period of alleged overstay, could not be made. Stop.